Good afternoon and welcome to today's session, which will be covering conduct outside of the profession for professional conduct panellists. Before we move to the substantive part of today's session, I'm just going to cover a bit about what Burkitt's does and introduce the speakers today. So looking at Burkitt's at a glance, Burkitt's is a full-service top 50 law firm with over 1,000 employees spread across our 6 offices. Today speaking, you have myself. I am Abby and I'm an associate in the employment team at Burkitt's. And I'll just hand over to Rebecca to introduce herself.
I'm Rebecca. I work in the regulatory and corporate defence team in our Norwich office, and I also sit as a legal advisor to the TRA.
I probably should have said that as well, Rebecca. I also sit as a legal advisor. On the agenda today, we thought it would be helpful to focus in on some of the key case law and look at things about conduct outside the profession, including the case of Beckwith, Frensham and Fouracre. As you can see, this is session 3. There's been a couple of previous sessions with some of my colleagues, which you may or may have not attended. And we have another session coming up, which will be highlighted at the end of today's session. So before looking at the case law, let's consider conduct outside of the profession more generally. So a professional is expected to conduct themselves appropriately in both their personal and professional life. And some of the cases that you may deal with as panel members will cover issues that take place outside of a person's profession in their private life, and you will need to consider the extent to which such matters are relevant to the individual's profession. Now, I'm sure we can all think of plenty of examples where conduct that may arise outside of the individual's profession, but just as an example, I saw a recent article with the ever-growing use of social media in our personal lives. There's a current case in the Solicitors Disciplinary Tribunal that you can read further about online that is considering tweets made on an individual's social media. If sitting as a panellist for the TRA and an allegation was found proven, as a panellist, you would need to consider whether that allegation amounted to unacceptable professional conduct or conduct that may bring the profession into disrepute. So misconduct outside of the education setting will amount to unacceptable professional conduct only if it affects the way the person fulfills their teaching role, or it may lead to pupils being exposed to or influenced by their behaviour in a harmful way. When considering conduct that may bring the profession into disrepute, misconduct outside of the education setting will be considered relevant only if the conduct displayed is of a serious nature and would likely have a negative impact on the public's perception of the individual as a teacher, therefore bringing the teaching profession into disrepute. So some of the key considerations that you'll need to be aware of derive from case law, and as I said, looking at today's agenda, we're going to cover some of that in more detail. So we've got the key case law, which I'm going to cover, which is Beckwith and the SRA, and then we've got some recent case law, including Frensham and the FCA, and Fouracre and the SRA, which Rebecca will take you through a bit later. So firstly, looking at Beckwith and the SRA. So just running through some of the facts of this case, Mr. Beckwith was a partner in a law firm and was subject to 2 complaints of professional misconduct brought by the SRA. After having drinks in a pub near to the office he worked, Mr. Beckwith engaged in consensual sexual activity. Although this took place outside of working hours, it was with a junior colleague, who for this purpose we'll call Person X, who he was supervising and appraising partner to. The tribunal found that Mr. Beckwith knew Person X was intoxicated to the extent that her judgment was impaired. It also found that Mr. Beckwith's judgment was also influenced by his own alcohol consumption that evening. However, the tribunal did reject the contention that Person X was vulnerable or that Mr. Beckwith had abused his position of authority over her. Nonetheless, it found that his conduct was inappropriate and breached the requirement that he act with integrity under Principle 2, and behave in a way that maintained the public's trust in solicitors and the provision of legal services, which is Principle 6. It held that his conduct affected not only his personal reputation, but the reputation of the profession. In particular, members of the public would not have expected a solicitor to conduct himself in such a way. The tribunal initially fined him £35,000 and ordered him to pay £200,000 of the SRA's legal costs. Mr. Beckwith appealed against to the High Court against the tribunal's findings that his conduct amounted to a breach of the Principles 2 and 6 and in relation to the costs order. So, in relation to the issues that the High Court had to consider, sorry, I'm just having a problem with the slides. There we go. In relation to the High Court's considerations, they had a number of issues that they had to look at. Firstly, they had to consider whether the threshold requirement that the tribunal should deal with only amounted to allegations that amounted to professional misconduct. Secondly, they had to look at whether Mr. Beckwith's conduct breached Principles 2 or 6. Thirdly, the extent to that Principles 2 and 6 interfered with Article 8, and that the extent obviously that had to be justified. And lastly, whether the cost award was disproportionate. So the High Court actually allowed his appeal and found that he had not breached his professional obligations. It was Mr. Beckwith's contention that the notion of professional misconduct was the boundary which marked the limits of regulatory incursion into conduct incurring outside of work. However, the court noted that the extent to which professional misconduct might play a part depended on the terms of the statutory scheme governing regulation of the profession in question. In relation to Principle 2, acting with integrity, the court held that the tribunal had erred when applying Principle 2 to the facts. It went on to consider the judgment of Rupert Jackson, Lord Justice, in Solicitors Regulation Authority in Wingate, who held, integrity is a more nebulous concept than honesty, hence it is less easy to define. In professional codes of conduct, the term integrity is a useful shorthand to express the higher standards which society expects from professional persons and which the professions expect from their own members. The underlying rationale is that professions have a privileged and trusted role in society. In return, they are required to live up to their own professional standards. The duty to act with integrity applies only to what professionals say, but also to what they do. However, it does not require professional people to be paragons of virtue. The court considered that 3 principles could be drawn from the above case, which I will consider on the next slide. In relation to Principle 6, the SRA submitted that the public would have had a legitimate concern and expectation that junior members of the profession would be treated with respect by other members of the profession. While the court accepted the view having regard to the outcomes and indicative behaviours set out in Chapter 11 of the 2011 Code of Conduct, the facts as found by the tribunal were not capable of supporting the conclusion that Mr. Beckwith was in breach of Principle 6. His actions affected his own reputation, and there was no qualitative distinction between that and conduct which affected his reputation as a provider of legal services or the reputation of his profession. But the tribunal had not explained its reasoning for how Mr. Beckwith's actions had crossed this line. In respect of Article 8, a right to respect for private life, this was actually a really interesting point. Mr. Beckwith argued that it was the case that regulatory rules such as Principles 2 and Principle 6 could, if it could reach wide enough to apply to conduct outside of work and outside of the profession, this interfered with his right to respect for a private life and the requirement to strike a fair balance between the individual's rights and the legitimate public interest. The court accepted the requirements to act with integrity and in a way that maintains public trust in the provision of legal services will, on occasion, require the SRA or a tribunal to adjudicate on a person's private life. However, neither Principle 2 nor Principle 6 had an unfettered application across all aspects of a solicitor's private life. And there's a quote on the slide that I'll just read out that was taken from the case. It said that there can be no hard and fast rule, either that regulation under the SRA handbook may never be directed to the regulated person's private life, or that any or every aspect of their private life is liable to scrutiny. But Principle 2 or Principle 6 may reach into private life only where conduct that is part of a person's private life realistically touches upon the practice of the profession or the standing of the profession. Any such conduct must be qualitatively relevant. And I'll just touch upon the last point in relation to costs, just so that you obviously hear the full outcome. His appeal was also upheld in that regard, and they said that he obviously didn't have to pay the £200,000 legal costs. The court commented that the factual issues were not complex, and actually the SRA had failed to prove one of the allegations, and so it could see no basis for that claim. So turning to 3 principles that were taken from the case that I mentioned earlier, they reiterated these at the end, and they said, firstly, there is an association between the notion of having integrity and adherence to the ethical standards of the profession. This is consistent with the ordinary meaning of the word integrity, adherence to moral and ethical principles. Secondly, there is an expectation that professionals may be held to a higher standard than would apply to those outside of the profession. And lastly, a regulatory obligation to act with integrity does not require professional people to be paragons of virtue. Overall, regulators are given a warning from this case that they could only reach into a person's private life when that conduct within someone's private life realistically touched upon the practice of the profession or the standing of the profession. Further, it's clear that regulators will need to strike a balance between the 2 competing interests, as I mentioned earlier. So the public interest in obviously regulating the profession, whether that be solicitors or teaching or any other profession, versus that individual's or the professional's private life. As you appreciate, this particular case engaged the SRA principles, but if you were, for example, sitting as a panelist on a TRA hearing, you would need to be considering the standards by which the members of the teaching profession should abide. So I'm just going to hand you over now to Rebecca, who will take you through the next of the cases that we're considering today.
Thank you, Abby. I think we need to go back 1 slide. No. There we go. So the case of Frensham and the Financial Conduct Authority, this was a judgment dated the 31st of August 2021, which was an appeal to the Upper Tribunal Tax and Chancery Chamber. And it was the first time the tribunal considered where the conviction didn't involve dishonesty, where behaviours unrelated to the regulated activity. Mr. Frensham was an approved person under the financial services industry sector. He'd worked in that industry for over 30 years. He owned his own firm, which had been established since 2009, and he had no regulatory complaints recorded against him. He held a senior management functions of the firm, sole approved person, and the majority shareholder within that business. Mr. Frensham was convicted by jury on the 10th of March 2017, having pleaded not guilty to attempting to meet a child under the age of 16 following acts of sexual grooming. He was sentenced in later in March 2017 to a suspended prison sentence of 22 months, and that was suspended for 18 months with 60-day rehabilitation requirement, and he was also made subject to an indefinite sexual harm protection order and on the sex offenders register until 2027. He obviously, as I said, had his prohibition. He was prohibited from performing his functions as an approved person for his regulated activity by the Financial Conduct Authority, and he appealed that decision. The FCA contended that the circumstances of the offending lacked integrity. They said the offence was committed in breach of pre-existing bail conditions. He was on bail conditions from 2016. He attempted to exploit a minor. He abused a position of trust and had a deliberate and a criminal disregard for the appropriate standards of behaviour. Further, in order to maintain the public confidence, and this is something you will see when you deal with your cases as panelists, it's a similar type of standard, the public confidence in the financial service industry. The FCA and the public are entitled to expect approved persons and financial advisors are individuals with integrity and good reputation. Whilst the offence was outside of his work and didn't involve financial dishonesty, but it involved him deviating from the legal and ethical standards and seeking to exploit those more vulnerable than himself, were relevant factors considered by the FCA. and therefore they felt this was fundamentally incompatible with his role as a financial advisor. Furthermore, he'd not been open and transparent about informing the FCA on a number of matters, which included his previous arrest and bail conditions in March 2016. It was reported to them by a member of the public when he was arrested and remanded in custody for the matter of which he was convicted. He didn't report to them that he was in custody or that there'd been a decision of the Chartered Insurance Institute expelling him from their membership. So there was a number of factors that were considered and submitted by the FCA. Mr. Frensham, however, believed the FCA had wrongly applied the fitness and properness test and that irrelevant considerations affected the judgment, and that's why he appealed. He said that the conviction did not relate to his regulated activity. It wasn't for an offence of dishonesty. It wasn't committed in the course of his work, and the nature of his work was unlikely to bring him into contact with a minor and put him in breach of the terms of his sexual harm protection order as he dealt with adults. And he felt there was an error in the lack of candour that the FCA said that he had shown. He also submitted that he was deeply remorseful. That hasn't been taken into account, and further that the FCA had not paid sufficient regard to the length of time since the matters indicating his unfitness or severity of risk that posed to the consumers and confidence in the financial system. So considering the fit and proper person test under the FCA guidance and the submissions, it was also noted that the case had attracted considerable national and specialist financial press publicity, referring to his status as a financial advisor. Some of his clients had been made aware of or become aware of his conviction and had stood by him, and a number of clients had become aware and declined to be clients further. So when the FCA consider that everything was put before the upper tribunal as part of the appeal, and having considered all the factors, they dismissed the application against him. Whilst they stated that they didn't agree with all the aspects of the case put forward of the FCA, and it is a lengthy and detailed judgment. What they did comment is that if they had been asked to decide the case on the basis of the conviction in the criminal courts alone, it was likely purely on the facts of that case that they would have asked the authority to reconsider their decision. However, they'd taken into account everything and the particular merits of this case. They considered there was other relevant factors in addition to the conviction. And again, this is something you will come across as panelists and will take into account as well. Similar type of factors. The fact that there was a breach of his bail, they deemed that it was a deliberate decision to disregard the law to satisfy his own interests. The failure to be open and transparent with the authority, and that there was no evidence of rehabilitation in his failures to comply with his duty of candour to the authority. So effectively, the way he dealt with the consequences of the conviction demonstrated the lack of integrity, and therefore were deemed to an extent more severe than the conviction itself. And therefore it was held that they were entitled, the authority was entitled to exercise its power of prohibition. And as I said, it was dismissed Mr. Frensham's application. And it did, as it referred to the case of Beckwith and other case law throughout that judgment. So that was that decision. Then there is a further case which also relates, like Beckwith, to a case involving a solicitor, was a trainee solicitor on the 1st of November 2021. This is quite a well publicised case, so you may have already be aware or come across of this. Mr. Foraker was a trainee solicitor. he had given a Christmas card to a colleague which had inappropriate and sexual references contained within it. Unfortunately for Mr. Foraker, prior to this, he'd already had a previous warning for behaviour, making inappropriate comments to a secretary at an office party, for which he'd apologised and accepted that comment was crass and juvenile. Following the Christmas card, he'd also given the trainee two presents with the card. There was nothing sexual or the context of that, but he'd given her presents and she'd given them back, and then sent some text messages to her after those presents had been given. So the SRA, this was reported, they investigated, this is Regulation Authority investigated, and the allegation was put to Mr. Foraker, and he responded via written statement accepting and apologising for his actions. The investigating officer considered that regulatory sanction, as he'd breached Principle 6, should be considered. And Principle 6 in the SRA handbook says you behave in a way that maintains the trust the public places in you and in the provision of legal services. The investigating officer, interestingly, recommended that Mr. Foraker be dealt with via a £2,000 financial penalty. However, the adjudicator took a more serious view, determined that Mr. Foraker had breached Principle 6. They didn't direct the financial penalty. They rebuked him, and they published that rebuke and ordered him to pay £600 costs. Now, he appealed on a number of grounds, but one of those was the wrong application and not taking properly account of the case of Beckwith. Mr. Foraker determined that the adjudicator had wrongly stated that the conduct had taken place in the office, and therefore Beckwith case did not apply. Having considered the principles in the case of Beckwith, particularly Principle 6, where it says it may reach into a private life only when conduct that is part of a person's private life realistically touches on practice of the profession or standing of the profession. It was determined that the question in this case was therefore not the location of where the conduct had taken place, i.e. inside or outside of the office, but this was a question whether the alleged breaches could, within reason, closely be tied to the guidance in the Solicitor's Handbook, which is very specific, unlike the financial conduct authorities, where they drew a distinction that the FCA do not have the similar type of principles as the Solicitor's Handbook does. It was accepted that the conduct of Mr. Foraker was reprehensible and tarnished his own reputation, which he accepted himself. And the tribunal agreed that it was deeply inappropriate and disgraceful in the manner that he had acted. However, the adjudicator decided that it breached Principle 6 was not supported by referencing matters set out in the Solicitor's Handbook. And this is what they should have done. So it was not satisfied that the adjudicator had correctly identified why Mr. Foraker's actions had breached Principle 6 within their judgment. So given that Beckwith clearly stated that analysis of conduct needed to focus on identified breaches of obligations set out in the handbook, and Principle 6 is the only basis for the case against Mr. Foraker, the Beckwith requirement was not satisfied. Therefore, the adjudicator's decision was revoked and Mr. Foraker was successful in his appeal based on the wrong application of Beckwith. So you can see that the case of Beckwith, the importance of that and how it's been considered in both these cases, and how the principles with Beckwith stand and as in your decisions and when you are given legal advice as panelists, how you will determine and consider the principles and the conduct both inside and outside of the profession. So in conclusion, everybody I understand here today is a panelist or a member of the TRA. So when sitting as a panelist and considering conduct of the profession, you must be satisfied that the conduct to which your allegations relate, whilst having taken place outside the education setting, nonetheless touch upon the teacher's role as a teacher, and then it gauges the standards by which members of the teaching profession should abide. I don't know if there's any questions for myself and Abigail based on the cases and this we've identified and explained.
I don't think there's any questions at the moment that have gone into the chat box, but if anyone's got any questions, then obviously feel free in the next couple of minutes to add those to the chat box function. Should we move on to the next slide and then see what comes through?
Yeah. So the final slide, which it isn't coming up, the wonders of technology. This, as Abby said at the start, this is a case. This is the third of 4 briefings and trainings, as webinars and trainings that we're delivering as a firm. The next one is in relation to, there it is, insight and remorse, and that is going to take place on the 12th of December this year. I know I'm not involved in that one. I think it might be other colleagues, Abby. I don't know if it's you as well, but that, and it's listed for around the same time, I understand, the 4:30 timing as well. So that will be another very interesting presentation discussing the implications of insight and looking at insight and remorse in the profession and in making your decisions. So please do join us for that one.
I think there's a couple of questions that come through. So let's have a look.
One issue raised in the case was how long ago the incident occurred. Did the tribunal make any comment on that?
I'm not sure what case that is. Which one was it?
I think that was the Frensham one. No, they didn't specifically make reference to that. They focused on the other matters rather than the conviction itself. It was the consequences and the surrounding matters, and so they made no specific reference to the time.
I think we've got one in, do we have to take a different view if someone's been convicted of a criminal offence? Interrupt me, Rebecca, if I'm wrong, but I think you'd be looking at the whether a relevant criminal offence has been committed or relevant conviction has been committed. More so if there's actually been a conviction. Are you happy with that, Rebecca? You wouldn't necessarily, even if it's outside, if there's been a conviction of a relevant offence.
Yes.
That's taken place outside of work, for example. I don't know, say theft, for example.
And there are cases that regularly do come across. Yeah. We do come across
conduct outside of teaching, things like that. That would be relevant conviction, and you'd be looking at the advice on that as opposed to the unacceptable professional conduct and or conduct that would bring the profession into disrepute. And then lastly, can you give an example in teaching where Beckworth may not apply? I mean, it'd be anything where it's obviously inside the profession. I'm trying to think off the top of my head. I think it would just be looking at if it doesn't touch upon a person's private life. So I'm just trying to think if I think there's been a couple, but one that comes to mind, for example, whether it touched upon a profession would be, for example, like an argument in a car park. That was one, yeah, just coming to mind, and the debate over whether that touches on someone's sort of their professional life, their professional job, and there was much debate over whether that does go enough into what the person's doing as a profession, as opposed to their personal life when they're just going and doing their shopping in Asda, for example. I can't think. I don't know, Rebecca, if you've got any other examples.
Come across any other.
I think it's really focusing back on the issues, as we said, in relation to Beckwith, and looking at the three key principles that the High Court reiterated, which are obviously on one of the previous slides, and in particular whether it does touch upon the person's professional role, whether that be teaching or a solicitor or accountant, and obviously the competing interests and balancing that out. So looking at so if it just got up burglary and drink driving, so if it was a conviction for burglary, then you'd be looking at whether there's been a relevant conviction. Rebecca, is that?
It's a relevant offence. It was in the case of 4 Acre, it was it was the principle upon which that it was applied. The investigating officer said that they purely cited Principle 6, and that was the decision that the SRA had to determine. If there was other principles that had been breached and put before, then such as integrity, maybe there would have been a different, we don't know, maybe there would have been different considerations, but there was no, in the actual case, there's no mention of sexual harassment or anything like that in particular. It was purely under Principle 6, and that's where it was said that the adjudicator wrongly didn't consider Beckwith.
Just so that I think, just because obviously they can't, the rest of the members or attendees can't see the questions, I think what Rebecca was answering was whether in the case of 4 Acre, someone was clearly sexually harassing another member of staff, and didn't that fall into bringing the profession into disrepute. What are the 3 points? I think that's probably referring to what I said about Beckwith, so I'll just read those out again. So there's an association between the notion of having integrity and adherence to the ethical standards of the profession. This is consistent with the ordinary meaning of the word integrity. Secondly, that there's an expectation that professionals may be held to a higher standard than those outside of the profession, so those undertaking roles such as teachers or solicitors, and a regulatory obligation to act with integrity does not require those professional people to be paragons of virtue. So obviously there's going to be issues that they may have, and they're not required to be held to that standard, but obviously just a higher standard than perhaps someone outside of that profession. Just wait a couple of seconds for any more.
There's no more questions coming through. So thank you. I said thank you all for attending today. I hope that's all been useful for you going forward. If there is anything that crops up or any question, then please don't hesitate to get in touch with myself or Abby and the firm, and we're happy to answer anything further if something crosses your mind.